Welcome once again to Lehto's Law. Here's Steve Lehto.
Got a very short email today with a great question in it. I encourage you to send questions to me. If you've got questions you think I should talk about on the show, I'm happy to hear them. Email me. The email address is at the end of the video or in the information page for the channel. I'm not that hard to find or get a hold of. So if you have questions, send them to me. Now, once in a while, people will send me a question. Say, Steve, you should talk about this. And it's something I talked about a week ago. But once in a while, someone comes along and fires a question at me. I'm like, wait, I haven't covered that yet? How is that possible? Keith sent me an email just this morning. And he says, Steve, I just watched your video on why jurors don't ask questions during a trial. And I talked about how, people say, if I'm on a jury and I've got a question, why can't I just raise my hand and ask a question of a witness? And I explained that in that video, so I'm not going to repeat that right now. But he says, this brings up the question of why judges don't ask direct questions of a witness like they do in England. He says, British judges. And so he says, I love your videos. I hope you enlighten me. And that's Keith from Missouri. And, it's a great question. And it's one of these things that, I hadn't stopped to think about. But yeah, it's a very interesting question. And so we'll discuss it. And so the summary of why jurors don't get to ask questions, generally speaking, is that the courts and the judges let the attorneys try the case, thinking that the attorneys know the case best. And so if something needs to get in front of the jury, they'll get it in front of the jury. And jurors can't always know what they're not supposed to know. For instance, if something's inadmissible, all it takes is one juror to raise their hand and go, excuse me, has he been convicted of a crime? And so you don't want a juror causing a mistrial by asking a question. So the first thing you need to remember is that there are two kinds of trials that are very, very different, but they are trials nonetheless. And that is defined by who is going to decide the facts of the case. Because generally speaking, you've got a fact finder and you've got a judge, and the judge is the one who rules on issues of law and conducts the trial. If you have a jury, the jury is the fact finder, meaning that the questions of fact are decided by the jury. Now, you can, in many cases, opt for a bench trial, which is a trial by judge. So if you want to, in a civil case, you don't have to demand a jury. You can say, I want a judge to decide the case. Now, the other side might demand a jury, but if both sides go, we're happy to have a judge decide this case, you get a bench trial. And I've done bench trials, I've done jury trials. Likewise, in a criminal case, if you want to, you can have a jury decide your fate, or you can have the bench decide your fate at a bench trial. And there's a lot of different reasons why you might decide to have a judge decide your fate instead of a jury. It just depends on how sympathetic you think you are, how tricky the questions of law are. There are famous examples of cases where somebody was accused of heinous crimes, and they thought, well, there's such technical issues of law here that a judge might understand, but a jury might just be so appalled by the facts of the case, they might not be able to. So let's go with the bench. And likewise, if you think that there's something sympathetic about you, you go with the jury, hope that they sympathize with you for some reason. But if you are having a bench trial, okay, that is a trial, no jury, and a judge is going to decide your fate. And if you are examining a witness, there's a good chance that the judge will jump in. I've done bench trials, and bench trials, judges have got no worries about jumping in and saying, excuse me, and they'll ask a question that they think they need the answer to. And it's an interesting idea because if they are the fact finder, why don't they act like the other fact finder? Well, the judge is, number one, allowed to run the trial any way he or she sees fit based on most states' court rules. Michigan's court rules specifically state that judges have broad discretion in how they conduct trials. And so the simple notion of the judge asking a question is not the exact same thing as allowing jurors to ask questions. But the presumption is that the judge, as fact finder, is going to be asking these questions, and the judge also knows which questions that he or she should not be asking if, in fact, those types of questions exist. So a judge very well could jump in and ask questions during a bench trial, and nobody would bat an eye. And I've said it before, and I just like telling a story because it's a fun story. But I had a bench trial involving an insurance denial, and we opted for a bench trial. And interestingly enough, the insurance company did too. And during the direct examination of the primary witness of the insurance company, the judge just stopped the attorney for the insurance company and turned to the witness and said, actually to both of them, goes, is this all you've got? Which a jury could never do that, or a juror could never do that, but a judge can. And the judge was basically getting tired of sitting there going, wait, when do we get to the actual meat of the matter? Oh, wait, there is no meat to this matter. So judges will jump in quite often. But that gets us next to the next question. We have the prototypical trial, right? Perry Mason, a couple attorneys, got a judge, and you got an impaneled jury. Okay, the jury is there. Why won't the judge ask questions of witnesses in that setting? And most often, they won't. Again, they can if they want to, but it's considered to be bad form. But again, like I said, the court rules in most states, especially in Michigan that I'm very familiar with, say specifically that the judges have broad discretion in conducting a trial in the way that they see fit, so long as it's within the law. And so there's no law that says a judge can't ask questions of witnesses. In fact, I've seen it happen, and it happens not a lot, but it does happen, even in front of a jury. But it's considered bad form, and there's a couple reasons why. One of them is quite simply that if the trial is being conducted properly and the attorneys know what they're doing and they've spent however long they spent preparing for trial, it's a good chance they spent a couple of years preparing for trial, okay? I've actually seen it happen more times than I care to explain, where I've gone into chambers on a case and start talking to the judge about the case with the other attorney there, of course. And the judge is very obviously like, what? Judge knows nothing about the case. Judge hasn't glanced at the file. Judge knows nothing about the case. That's not uncommon. And in fact, a lot of times for trial, you prepare a trial brief. And one of the things that the trial brief is designed to do is to get the judge up to speed about the case is about. And so the judge may have conducted a murder trial yesterday and could be conducting a civil lawsuit today. So the idea that the judge is going to be like in tune with, plaintiff's counsel, defense counsel, and the judge, and all three of them know what's going on. No, that's not the case. The attorneys know what's going on. The parties know what's going on. The jury is a blank slate, and the judge might be as well. So the idea that the judge could have a question pop into their head and decide to ask it of a witness, the judge knows that, hey, I'm not as up to speed on this case as these parties are. I'm going to let them put the information in, and then maybe my question will be answered. And then, of course, that's the other thing. And a lot of judges will defer to the attorneys and let the attorneys conduct the trial in the way that they want to conduct the trial. And the thinking is that there might be a strategy involved. There might be a particular reason why they're not doing it one way or they're doing it this way. And whose job is it to second to guess the attorneys on how they're handling the case? Now, I remember in the video I did about why jurors can't ask questions, I was talking about, for instance, the most obvious one is when I, on cross-examination, will ask a series of questions, and I'll stop, and I will not ask the last question. I will actually stop and say no further questions. And then during closing argument, I'll say, as you recall, that witness said this, and this, which leads you to this conclusion. And there's no getting around it. That conclusion, if I did the cross-examination properly, that conclusion is carved in stone, whether I'd asked the question or not. And I had several people get angry and say, Steve, that's game playing. The fact that you don't ask that question, you're scared of the answer. No, you do it for dramatic effect. And if you think that there's something wrong with trying to make the story interesting for the jury, no. I've seen jurors fall asleep. I've been in a courtroom where a juror fell asleep. I've seen a judge fall asleep. Anything you can do to keep these people, judge, jury, to keep these people awake is a good thing. But understand that both sides have attorneys. So while I'm doing that to get my side of the story in, they're doing that to get their side of the story in. And by the way, the last question that I don't ask, the other side can ask it if they want to. If they missed it, that's their fault. Okay? It's not my job to make everything easy for everyone. It's my job to represent my client and get the best result I can for my client. It's the other attorney's job to get the best result for his client or her client. Okay? So a judge who is wise and is on the bench and has a question pop into his or her head will quite often go, I'll make a mental note and see if it gets answered during the rest of the trial. But I'm not going to jump in and screw things up because it might get answered down the road. There might be a reason that it's not an issue that I think it is. I hate to use the analogy because it's actually not a legal one, but it's kind of like you take someone to see a movie that you've seen before, and they turn to you 30 seconds in and go, "Hey, what's this? What's going on here?" Okay, don't talk to me. Watch the screen, and maybe your question will be answered. Because if the movie is good, it will be. Okay? So the idea that the judge might have a question occur to them in front of a jury, most judges will not ask that question because they're going to wait and see if it gets answered on its own. I've actually had a judge ask me after the jury's been let out, "Mr. Lehto, what about this?" Out of curiosity. But it wasn't something that would have made or broken anything in the trial. It was just something that, the judge had a curiosity thing. But we've also all seen or heard of situations where a judge, even in front of a jury, got bothered by something and interrupted and inserted themselves into a line of questioning, for instance. And, like I said, generally speaking, the attorneys examine the witnesses. And now there might be objections that the judge will rule on, but for the judge to say, "Hey, I got some questions," would be inappropriate. It's not wrong, and they are allowed to do it. But the primary reasons they don't is that they're going to let the attorneys handle it because the attorneys know the case better than they do, and the attorneys are probably doing what they're doing for a particular reason. Now, I will also just full disclosure tell you that I've seen it before where after a trial is over and people are talking, the attorneys are talking to the jurors who've decided to stick around. Quite often a judge will tell the jury, "If you guys want to, you can stick around and talk to the attorneys because it's often enlightening for them to deconstruct what happened at the trial." And I've had some jurors just take off and go home because they've had enough of this nonsense. And I've had other jurors stick around and say, I'd be happy to talk to you. And what's funny is how often jurors are on a completely different page than not just one attorney, but both attorneys. And I've seen that in cases that I was involved in and in cases that my friends were involved in. And I've heard stories also where every single one of the jurors is like, "Why did nobody bring up this?" And I've seen it before where it couldn't be brought up because of a particular reason, like it was inadmissible, or the attorneys didn't think anybody would catch it. And once in a while, they're wrong. So that's why, being a good attorney, especially a trial attorney working in front of jurors, you don't need to just know the law or just know the procedure or just know your case, but you also have to have some good understanding of human nature. And it's interesting when you see, once in a while, you'll see attorneys who are so hyper-focused on their case that they lose track of the fact that no matter how good you are as an attorney, it's 8 civilians who are going to decide your civil action, or 12 who are going to decide your criminal action. And they're not thinking about it like attorneys are. They're thinking about it like wherever they came from in life. A teacher's thinking about it like a teacher. Pastor's thinking about it like a pastor. And so that's really something that a lot of attorneys, I think, are surprised by when they try a case and then go talk to jurors afterwards. And the jurors are like, "How come nobody addressed this or nobody brought this up?" And like I said, once in a while, it's because we couldn't bring that up, right? But there's other situations like, "Really? You guys were worried about that? Like how? Really?" So it's an enlightening thing. But generally speaking, like I said, if it's a bench trial, the judge can and often will ask questions. If it's a jury trial, they could, but they more often than not defer to the attorneys because, number one, the attorneys know the case better, and they're thinking that the attorneys are probably doing it a particular way for a particular reason, and they could be wrong. But that's what the question is answered. That's how the that's how the question is answered. Keith from Missouri, thanks for it. Talk to you later. Bye-bye.
Thank you for watching Lehto's Law. The hardest piece of software to change is between two ears. But for some people, it's more of a hardware problem.